everybody. Bill Sack here, Director of Legal Operations with the Second Amendment Foundation. It's not every day that I get to come on here and tell you, the adoring SAF Nation, that the Supreme Court has agreed to hear a new gun case. But this week, that is precisely what I'm here to tell you. The case is Mexico versus Smith Wesson, and it is of critical importance to both the American firearms industry as well as the American people writ large, because, after all, the right to keep and bear arms requires first the ability to acquire them. In the case, Mexico has sued Smith Wesson for $10 billion, that's with a B, dollars in damages, alleging that the gun maker is somehow responsible for the scourge of cartel violence that is plaguing our neighbors to the south. The district court originally tossed the lawsuit out on its culo, but for reasons not entirely clear to us here at SAF, the First Circuit resurrected the case by overturning that dismissal. At the core of the case is the Protection in Legal Commerce in Arms Act, or the PLCAA, which was passed in the late 90s to protect firearms manufacturers from the costs associated with defending against precisely this sort of lawsuit, namely those designed to bankrupt the industry not by winning lawsuits against them, but by way of the punishing costs of litigation itself. SAF has filed an important amicus brief in this case earlier in the year, making clear that Mexico's assertion of liability for the third-party criminal misuse of firearms that Smith & Wesson legally manufactured and legally put into the stream of commerce was entirely without legal support, and contrary to the protections granted expressly by the PLCAA. We will be watching this case closely as it moves forward in the Supreme Court, and we will, of course, be keeping all of you updated along the way. I'm Bill Sack, Director of Legal Operations with the Second Amendment Foundation.